If you've witnessed wrongdoing at work and you're wondering whether to speak up, or you already have and now you're facing consequences, this video is for you. Whistleblowing law is specific, but it gives you real, enforceable protections. Here's what you need to know. What is whistleblowing? Whistleblowing, formerly known as making a disclosure in the public interest, is when you report wrongdoing to your employer or a relevant regulatory body. The key legislation is the Public Interest Disclosure Act, 1998. To be protected, your disclosure needs to relate to one of 6 categories of wrongdoing: a criminal offense, a breach of legal obligation, a miscarriage of justice, a danger to health and safety, damage to the environment. From April 2026, a sexual harassment disclosure, a deliberate attempt to conceal any of the above. What counts as a valid disclosure? You don't need to prove the wrongdoing actually occurred. You just need a genuine, reasonable belief that it has happened or is likely to happen. If your belief turns out to be wrong, that alone won't strip you of protection. However, rumors and unfounded suspicions aren't enough. There needs to be some factual basis for what you're reporting. It's also worth knowing that personal grievances, such as bullying or harassment, are generally not covered by whistleblowing law unless there is a broader public interest element. Those situations should be dealt with through a formal grievance process instead. Protection is wide. It covers not just employees, but also workers, freelancers, agency staff, and directors. If you're providing a personal service, there's a good chance you're covered. How to make a disclosure? In the first instance, make the disclosure to your employer. However, if you believe they will cover it up, treat you unfairly, or have already failed to act on a previous report, you can go directly to a prescribed person, an independent regulator relevant to your industry. Crucially, keep a written record of everything. Note what you disclosed, when, and to whom. This evidence can be vital if things escalate. If you've made a protected disclosure, you have the right not to be dismissed or subjected to a detriment because of it. Dismissal for whistleblowing is automatically unfair, and there is no minimum length of service required to bring a claim, unlike standard unfair dismissal. Detriment can take many forms, including demotion, being denied promotion, unreasonable performance targets, pay cuts, bullying, suspension, or even failure to provide a reference. The key is that there must be a clear link between your disclosure and the treatment you've suffered. Your employer will need to show the treatment was for another reason entirely. One of the most important features of whistleblowing law is that there is no cap on compensation. Unlike standard unfair dismissal, awards are uncapped and cover both financial loss and in detriment claims, injury to feelings. However, if a tribunal finds your disclosure was made in bad faith or for personal gain, it can reduce your award by up to 25%. Time limits are strict. You must contact ACAS under their early conciliation process within 3 months less 1 day of the act you're complaining about. Don't wait. The clock starts running from the date of the detrimental act, not when you first instruct a solicitor. Speaking up about wrongdoing takes courage. The law recognizes that, and it gives you significant protection when you do it correctly. If you've blown the whistle and you're facing consequences, or you're unsure whether your situation qualifies, seek legal advice from Duncan Lewis as early as possible. At Duncan Lewis Solicitors, our employment team supports clients through whistleblowing claims at every stage, from understanding your rights to tribunal representation. Contact us today to discuss your situation.